Switch the gears from debt buyers to original creditor lawsuits, because there is a difference between being sued by a debt collector and being sued by the original creditor. So if Chase opened your account and Chase is the company suing you, we are dealing with a different type of plaintiff than a company that, again, is considered a debt buyer. That doesn't mean that you just throw your hands up and say, well, they're the original creditor and, I definitely don't have a chance now. No, it means you need to understand what changes, what they may actually have, and where you still need to pay attention, because just because it's the original creditor, yes, they'll more than likely have more paperwork or exhibits than a debt buyer. At the same time, they still have to, again, show how they calculated balances and other things. So that is where we're going to get into this video at, okay? Same courtroom, different opponent. So an original creditor was actually there when the account was open, right? They may have your application, they may have your statements, okay? They may have your payment history. They may have records that a debt buyer never even would receive if they did purchase the debt. So I do not want you using the exact same strategy for every lawsuit just because it involves a debt, because again, over here we are very strategic. You need to know who is suing you first, because again, who is suing you changes what you should expect to see in that particular case, if again you are being sued by the original creditor. What they typically have on file, right? So let's talk about what the original creditor may actually have. They may have the application or agreement. They say the account, right? That they say created the account. Your contract, they say created the obligation. They may have years of monthly statements showing charges, payments, interests, fees, right? Those monthly statements. They may also have your payment history, right? Including the date they claim you last paid. All right. So this is not necessarily a case where you are looking at a bunch of missing paperwork from a company that brought a spreadsheet like debt buyers do. The records, again, are 9 times out of 10 going to be more stronger because you are dealing with the original creditor, but stronger paperwork still needs to be examined, right? Do the numbers match? Is this the correct agreement, right? Do the records actually support what they are asking the court to award, right? Those are still fair questions. So it's not all hope is lost because it's the original creditor. Having records is not the same as getting them admitted. Business records still have to come in under the rules of evidence through someone who can establish how they were made and kept, right? So that is the big distinction, okay? Having records and actually proving those records in court are not the same thing. A company cannot just walk in with a stack of papers and just drop them on the table and say, here you go, judge. Evidence still has rules. If they are relying on business records, there generally has to be a proper foundation for those records. So somebody has to be able to pretty much establish how those records were created and how they were maintained. So when you see a big stack of statements, do not automatically confuse the amount of paperwork with, oh, this is all of their proof and pretty much I'm just SOL, right? You still need to understand how that evidence is being presented. And also, if you are being sued by a debt collector or original creditor and your deadline is coming up, you don't know what to do, you don't know what to say when you get to court, which is like one of your biggest things. How do I defend myself? What do I say? I have the no surrender litigation plan. We do not surrender over here. You literally have to show up and fight. So you need to go in there and fight with a strategy. I walk you through, again, the moment that summons gets on your, or you see that summons, I was about to say gets on your desk, but you'll pick up the summons, or it'll get mailed to you. The moment you see that summons to the moment the judge dismisses the case or whatever the outcome is going to be, I walk you through that entire process, getting ready for court, cross-examining witnesses, because again, with the original creditor, likely there'll be somebody there, that they say is that works with the company, and that you might have to, you're going to get the opportunity to cross-examine, that you're going to be able to ask questions to. So that is really important, because you need to know what questions to ask. If you don't know what questions to ask, get the entire playbook. And if, again, that's not just, even if you know what questions to ask, you still need a full roadmap, and you still need a step-by-step play, because your deadline is coming up, and obviously you may be watching this video because you're being sued by a original creditor right now. If you're being sued by a debt collector, it works for a debt collector as well. I split it into two. If you are being sued by a debt collector or a creditor, I literally map it out for both parties. Okay. All right. Moving on. Where these cases get tested. Okay. So this is where we're going to test their paperwork, right? The math. Interest fees and credits do not always reconcile with the amount demanded. Okay? So if they are demanding a certain amount, but when you're looking at the paperwork, the numbers aren't adding up to that amount. How are you asking for this amount when the records don't show that this is what's owed, along with interest? Even if it's interest and fees, the numbers still have to add up. The math needs to be mathing. Which agreement applies, right? Card terms get amended. The version they rely on matters. So, do you have the original agreement that I signed up with, or I signed, or you have a generic version, right? Which agreement applies? And again, you definitely have to be petty or very strategic, ask a lot of questions, especially when it comes to the original creditor, because this is not a debt buyer. They have stronger paperwork, right? And then the contract terms. Some agreements contain clauses that change where and how the dispute proceeds. So this is going to be your arbitration clause, and it's another video. If it hasn't dropped already, it'll drop soon. Arbitration clauses, right? That is very, very important, because you can get the case dismissed that way, right? When you're going through, when a I'm sorry, when an original creditor is suing you, right? In that agreement, there may have been an arbitration clause, which arbitration is just another venue to handle the dispute outside of a regular courtroom, okay? So you may be able to get the case dismissed based off of improper venue, because the contract that you actually signed is supposed to be handled in arbitration and not the courtroom. All right. Strong paperwork is not automatic proof. It is a starting position. Every element of their claim still has to be established, and every element can be examined, right? So I really want you to remember that sentence, okay? Strong paperwork is not automatic proof, right? There's a difference. They have statements, they have the agreement. They, again, 9 times out of 10, they have the payment history. Okay, now what exactly does each document prove, right? Does the agreement match the account? Does the balance all add up, right? Can the person presenting the records actually establish what needs to be established, right? Every part of the claim still needs support. So do not get intimidated just because their exhibits look like they're either thick or they have them all organized or whatever the case may be. I promise you, these are real people just like me and you. And again, you are doing yourself a service by just showing up versus the over 90% of people who don't show up and get default judgments. Y'all, I hope y'all know that, right? The majority of debt collection cases, people being sued for debts, they are won by default judgment, not because they showed the judge that they're legally obligated to sue, not because they had strong paperwork, not because they had a great system, not because they had a great attorney. Listen, because consumers aren't showing up. All right. So if you are dealing with a debt buyer, right, you may be heavily focused on ownership and things like that. But if you are dealing with the original creditor, some of those issues may look, again, completely different. So yeah. All right. Different plaintiff, different strategy, right? And this is the biggest takeaway from this class. Different plaintiff, different strategy. If you're, again, dealing with a debt buyer that focuses on one thing, again, they are a little bit, no, not ain't gonna lie, not a little bit, a lot of bit more easier to deal with, because again, they're third party, and debt collectors purchase from other debt collectors, so stuff can get mixed up easily. But if you're dealing with the original creditor, again, that's a whole different case, right? So the mistake a lot of you make is treating every debt lawsuit exactly the same. Inside the Go to University, I want you to learn how to identify who is suing you first, then understand what that particular plaintiff should actually be able to prove, okay? Because that's really, really important, because once you know who you're dealing with, you can start looking at the case with a certain set of eyes instead of trying to guess and figure it out, right? Or assume that one, if no matter what the case is, or no matter who the plaintiff is, as long as it's a debt collection lawsuit, I'm supposed to be handling it the same, and that is far from the truth. So, like I said, if you are being sued by a creditor right now, the whole roadmap, okay, that you need is in the description box below. And let me say something. This is not a, this is not, it's in detail. I made sure this was in detail, okay? Cross-examining witnesses, totally dismantling their paperwork or their evidence or exhibits that they say, or they have. All of these things, what to look for in these documents, all of that. Inside of the school community, of course, we go even deeper, right? Because it's hours worth of classes, hours and hours and hours worth of classes and research. But if you want a fast track, go ahead and grab the blueprint and the roadmap in the description box below. And I will see you guys inside of the Go to University.